only time I'll use state court is if it's to defend against an eviction in a lending case or a rental case or whatever. Then I can file my fair housing claim as a counter complaint, remove it into circuit court, because under Elliott Larson, circuit court has exclusive jurisdiction of Elliott Larson claims, and make a request for injunctive relief, or just make a motion to have the counter complaint removed into circuit court. That process right there can take, depending on the district court and circuit court, it can take months for them to sort that out. Sometimes they just throw up their hand and say, you know what, just refile your case, refile your counter complaint in circuit court. Well, I have to change the caption and switch it all around. Well, that's fine, just do it, do something. Last case I had to actually trace down the counter complaint in Wayne Circuit and work with supervisors and that to actually get it filed. They lost it, they didn't know how to handle it, it got put off to the side, and that's where it's sat. But the reason you want to do it, if you lose on the eviction part, you're right back into circuit court anyways on an appeal, and it's going to tie the case together anyways. But that's what you have to do. You can't go into federal court in that situation because there's abstention, Anti-Injunction Act, other doctrines in that which will preclude a federal court from enjoining actions of a state court. And you can't, well, we're not a ton of state judges or anything, we're just going against the defendant. Well, no, the court says no, it still requires an order by you're still ordering the district or the state judge to do something, and that's not proper. So you have to, so in eviction type cases, I will put those and leave those in state court system. Other than that, jurors are impressed. They don't get to federal court very much. It's a big deal. They think it's a very big deal case when they come into federal court. Judges in federal court are much better at applying the Fair Housing Act and civil rights statutes. If you are concerned about it, if you're asking for injunctive relief to stay it, I've got a brief on the CD which talks about that. There's broad federal principles that will apply to your federal claims when you keep them in state court anyway, so the state court judge will have to be using federal law in state court. And they kind of like that, something different for them. Because there won't be a lot of state law on point in it. That's the main thing about complaints. Tell the story. They will pick it up later on. They'll even pick it up on your summary judgment motion as well. See it coming up. Should be popping up. There's two aspects, though. I want to emphasize this right off the bat. When you file your case in court, and here's the question. Now the pleading standards, there's Iqbal and Trombley. Should be, what do I say here? I can barely see mine. Where the Supreme Court give heightened pleading standards, and they're applying that as to all cases. It's coming up. Slow. Has anyone dealt with that? No. There's probably, what? At one count there were 3,000 Iqbal motions or whatever, probably Iqbal decisions, Iqbal and Trombley. That looks kind of small, doesn't it? Let me come back to 1 second. Oh, this has the standard for what you file in state court. There, sorry. Strange. So just to stop the state court, motion is set, there was a default entered. Answer from defense's counter complaint, motion order for escrow. We're offering to pay escrow, Your Honor. They didn't even ask us. We did it voluntarily. We're such good faith. And then jury demand, and I like to do the, if I can, full discovery, although now in district court you got to ask for permission for discovery. I should do motion for discovery. I should have all my discovery attached, and it should be a request to remove the counter complaint into circuit court because it exceeds jurisdictional limit, plus notice of taking depositions. You could put all that in your initial pleadings. This stops the process. But again, I wish there's institutionalized persons and Religious Freedom Act, I think that's the name of it, in 2000. And it said that has to do with like churches, mosques, whatever, were having trouble getting land use permits. And often they would be, the municipality would go after them for code violations and so forth. Well, Congress put a provision in that law that a state court proceeding will not receive full faith and credit in subsequent proceedings under federal law unless that claim had been fairly adjudicated in state court. I wish we had the same kind of provision in the Fair Housing Act. We don't. We don't have it in sections 1981, 1982 as well. So the problem is if you get a judgment in state court, I call it landlord court or mortgage court because the landlord wins and the mortgage company wins in those courts across the country, by and large. That can be res judicata collateral estoppel. Courts are supposed to treat those as discretionary doctrines. They don't. You don't often get full discovery. You don't get the full kind of protections that you would in a regular civil proceeding. It should not receive that kind of preclusive effect, but it does. You have to ask fast or those claims will be lost. But get back to, there is, this is reconsideration. Sometimes federal courts will dismiss your state law claims. I have a couple orders in federal court where they keep the pendant or supplemental state claims because they're in the same facts. There's no confusing standard in terms of proofs and so forth. So it's a mistake for judges sometimes to dismiss those without prejudice. There is, if I just go in order. Any questions? Easy if I go right in order here. And that's a stipulation to remove the case into circuit court. There is the standards in federal court. There's Ashcroft, and Iqbal, and Twombly I didn't cite. But the key one is Schwerkowitz, it's 2002. It was held as good law in Iqbal. That says that in a civil rights case, a plaintiff doesn't have to allege a prima facie case of discrimination. Courts that look at Iqbal and Twombly without looking at Schwerkowitz really made a bad, it's just wrong. So when I see a court of appeals decision, I think on the listserv, Stella Adams cited a Sixth Circuit case where they didn't even cite Schwerkowitz. Decisions that case cited did reference Schwerkowitz, so there is a lesser standard. Here's the concern. If you're facing this kind of a motion, you must, within 1 year, timeliness, file a complaint with State FAP, Michigan Department of Civil Rights, or with HUD, get your discovery. Then at a certain point, you can either keep it in administrative process or then file it in federal court or state court, preferably federal court. But if you don't have enough and you're facing one of those motions, you've got a problem. The difficulty comes when you get a case after timeliness, it's beyond 1 year, you don't have the opportunity to file an administrative complaint, so then you do have to make sure that you have enough investigation on informally to survive those. And one way you can do it, again, you have to show that it's plausible. I do it is what? As much facts as I can, and then also do attachments to the complaint. Looking at Iqbal and Twombly, some of the courts will say, hey, we've got to take into consideration not only what's alleged in the complaint, but what's attached to the complaint and treat it all together. So they will look at that on a plausibility standpoint. Mistake I made here, I wasn't really ready for it. There was a cause determination in this case by the Michigan Department of Civil Rights. I should have mentioned that in the complaint. I survived this motion, but it would have been a much easier road if I would have just attached that. So that's my mistake. But that's a concern. It was not a concern at the federal level until the Justice Department got one of their cases dismissed. Then suddenly, Iqbal and Twombly meant something to the world. Before that, they didn't care. By the way, can you use Iqbal and Twombly in attacking the defendant's affirmative defenses?
Yes.
Sounds fair, right? Yeah, there's case law out there that says that you can do it. So you got to decide whether you want to. What's the concern? Defendant really hasn't had to take it from the defendant's side. They haven't had an opportunity to do any discovery. They don't know what the facts are. And you can prematurely kind of preempt their defenses by a well-timed motion right at the get-go. And so if you get the standard boilerplate affirmative defenses, those affirmative defenses are not satisfying Iqbal and Twombly. They're just conclusions. They haven't shown any plausibility that those fences will carry the day. Rule, discovery plan, there isn't much to say. These are fairly standard. The key thing in any case is electronic discovery, internet, emails. It's hard to think of a housing transaction today that doesn't involve the internet. Hard to think of one that doesn't involve some kind of electronic materials. If you don't get that, we're not doing our jobs. It's out there. Absolutely. And so you have to really do it. One case I had with testing evidence, like I mentioned previously, where with the computerized system, you could take a test, like say the test, I think this was like May 8th or whatever. They could go back through the computerized system and look at the units that were vacant or occupied as of that date. They not only did monthly reports, but they could go back in the software and look at that particular day. How pertinent is that? It's really relevant. It's amazing the kind of data that you can get. I like, when I get the case, I put everything in the case on one big giant PDF file bookmark. So I have it all there on one big file. Then when I have to do rule disclosures and things like that, I just burn it onto a disk and that's what I give. It works. It really works. It saves a lot of time, saves a lot of paper. I even asked for discovery in electronic format. I really don't want the paper copies. This is the motion to stay. If you have, probability of success on the merits of your fair housing claim or civil rights claim, irreparable harm is presumed for purposes of doing the test whether the court should grant injunctive relief because of the high policy given to civil rights. So that's very favorable. There's interrogatories, document requests. Here's, again, you think it's what? So you get information to prove your case. Yes, that's true, but you're also narrowing the defendant. What's the first thing that you want to do? Well, I ask for witnesses. I like to subhead it on information on expert witnesses. But here's the key one. I was at a seminar years ago it was an employment matter. This is the question that you must ask. State each and every non-discriminatory reason or reasons you intend to allege or assert as a defense of the claims in the complaint. If you don't ask this right out of the box, you're making a mistake. Use this in disparate treatment, intentional discrimination, direct evidence, reasonable accommodation or modification, retaliation, anything. Use this across the board. Make them tell you that. And then there's follow-up ones in here with each everyone. You have to ask all evidence that you have. Later it's going to ask them to produce it, all witnesses, any other persons with knowledge, all documents, and then have them produce it. It's amazing how this cuts it short. And you find out. And then combined with that, you want to ask who has had contact with your plaintiff or plaintiffs. Every person, whoever was involved in the decision-making process. When it comes down to trial, they want to bring this witness up. Your Honor, they answer in your argument, this person was not one of the people that interacted with the plaintiff. And the question is, well, why, counsel, are you calling that person? Well, Your Honor, they'll tell this. Your Honor, they had no contact with the plaintiff. That person shouldn't be permitted to testify. Right? It goes a long way. It really narrows it. And the judge said, I don't know how much time we should spend on trial with this person. So you want to ask those kind of things. Also, combine with it request to admit. Absolutely use request to admit. Did the plaintiff's prior rental history do you admit that the plaintiff's prior rental history had no bearing on this reason to evict? What do you think? Did they move to evict based on prior rental history? Practically speaking, well, no, the person's already occupying it, so what did the prior rental history have to do with it? Absolutely nothing. But if they admit, no, we didn't base it on that, then what about the fact that he had 3 or 4 prior evictions? Should that come in? No. Narrow it down. How about a prior bankruptcy? You can think of all kinds of things. Ask those in request to admit. And, people regularly are doing it. People sometimes, they don't answer on time, and they get deemed to admit. I can show an example of one. Here, this is a state court one, and this got all favorable answers. If we had time, I could go show answers to the request for non-discriminatory reasons. And I want to know about all their exhibits. Here's one. On the notice to evict. Attached notice to quit, they only checked off. Reasons checked was because your tenancy is ended. Other, 30-day notice of non-renewal lease. Admit that those are the only reasons that were checked off. What can they say? Yes, that's the only reason. kind of an obvious one, but it's really just a lead into the next question. Do you admit that his payment history is not listed in the letter and the notice to quit? Admit. Do you admit that the prior residential address is not a reason? They even said didn't carry insurance. That wasn't listed as a reason. This really narrowed it down. So you want to ask that. Clearly ask, request to admit. Nail down the non-discriminatory reason and then narrow down other defenses as well. Other than that, I just want documents. I don't care what they tell me in interrogatories. I don't want them to do a lot of explaining during the interrogatories. That prepares someone. On our side, you get this, what? Before they do a deposition, they give a great set of interrogatories, document requests and interrogatories. So you got to sit with the client, you got to go through everything about what happened, and then by the time you go through the exhausting process of answering the interrogatories, guess what you've done? You just prepared for the deposition. Never do it. I was taught, do not ask those questions. You catch them in a deposition. So the only exception is because I want to nail somebody down. That's why I'll do it that way. Even if I think I can do it right there. I can narrow discovery, narrow the focus of the case. Other than that, I want to hold back with that discovery and surprise them. I don't want to prepare them. Deposition is not for me to go in and ask the questions that they've already seen on paper. How about a notice of taking deposition? That can be an attack mode too, because you can, if you don't know who's doing what, you can use this in any case, you can ask them to designate the most responsible person with knowledge on whatever topic you want covered during the deposition. I don't want to guess who's going to come in and testify about files, or who's going to come in and testify about their non-discrimination policy, or whatever it is I want to get at, and I'm not even sure. I know they have the property manager, and I know there was an owner, but the other people I'm not really clear about. I want designated representative, and they're likely to come in and say this, and they'll say, well, no, there isn't anybody, it's just the resident manager. Oh, for this one, it's the resident manager. So then you get to trial, no one else can dare come in and testify about these matters, because I asked them to designate the representative with knowledge on those topics. Narrow them down. Because they're going to get the most presentable personal witness to come on that had really nothing to do with the case, and the jury may buy it. And these are just motions to compel. Those are fairly standard. And ones where they have been granted. I want to show just a couple of things. What's the most crucial evidence in a case? Testing evidence? If you had to pick one thing, what would it be? What would be your most crucial evidence? What do you think? What would bother you? What's the bothersome thing about discrimination?
I'd want to hear an admission, but probably an eyewitness.
Or you can rent, you can't. How about that? I'm ignoring your flaws, and I'm not ignoring someone else's. Why? It cuts through, I can see this better. Here's one. Here's an example. Right? The plaintiff got turned down for a loan modification. They didn't count her unemployment income. They were, through discovery, got 26 files, able to identify white borrowers who received loan modifications even though they had unemployment income. Look at this. This is from the file. You can see, I don't know if you can see it that well. But read this. Tell me why this person or couple got a loan modification. Look at this. Her husband had lost income about 3 years ago from being laid off at work. Since then, he recently found a part-time job, now back at work, but at a reduction of hours. Since she was breadwinner for a couple years, that her husband went out of work, was able to support all the bills. When she laid off about a year ago and placed on unemployment, that's when financially things were a struggle. As a result, she and her husband exhausted their savings, needed a 401k loan to stay current, to help with, and a credit card to help with groceries at times. Then she diligently worked with a lender to get into a trial period and fell behind just over a month to do the program. She called as a step of this program, make sure she's set up for success. We looked at her financials, no longer having the income. I mean, on and on about how terrible their situation is. It doesn't get any better. She is diligently looking for more income to help in affording her bills. In the meantime, has about 2 months reserves on this credit card to help her in buying her time to supplement income. So what do they have going for them? Nothing. Why are they getting a loan modification? You can talk about statistical evidence, talk about anything else like this. This kind of stuff is so compelling. What do you think? You think, oh, people don't get loan modifications. You look at these files, you find out, wow, when they do loan modifications, they do it. I mean, they take someone with $150,000 principal balance on their loan and make it $20,000. I'm not kidding. Oh, yes. You don't know it till you get in the files. They turned her down because they said that her unemployment was not going to last 9 months. When I went through the 26 files, I found 4 different ways they got around it. First, they said, well, the 9 months counts from the time you first applied for your loan modification. So if you go all the way back, we're within the 9 months. So it doesn't matter if your unemployment's going to end in a few months. They date back. Then they use this Department of Labor unemployment benefit extension tool. That's how they work with people. You know, others, they say, well, you got an extension later on in the process. So there, I mean, all different ways they found a way not to turn down white borrowers with unemployment income and getting a loan modification. But you don't know it till you actually look at the files. So that's really where you're going with your case. The rest of it, you can get there. Yeah, I want to know the policies and procedures. I have some of that. There's, you know, Federal Reserve has those guidelines and that, but not till you actually see side by side on the individual comparable files that the case really jumps out. I can go to trial on this case. You just read what they did on their files. Why are these people getting a loan? And it's time and again you see this. Not only this, then you see they've got these servicing screens, all kinds of things. You know everything about how they do business once you're done reading it. Home modification worksheet. See, per underwriting, unemployment benefit extension tool, benefits will continue for 9 months from TPP and so forth. You know, people I see, they say, oh, you don't, they kept asking for the documentation to turn in. You don't even have to turn in your documentation until you finish your trial payment. It just has to be turned in when you do your final loan modification paperwork. That's when it gets turned in. You wouldn't know it from looking at the way people understand it. And so that's how they come up with that. They know there's a 9-month rule, but they get around it time and again. That was the whole purpose of the unemployment benefit extension tool. And this shows the date of when they got their loan modification, so you can match up to show how many months passed. Let's show you another one. This was the eviction case. He was turned down, they said, because it was just termination of tenancy. The reason is we have prior eviction cases filed against him. It happened so much, we're going to get rid of him. We just have to let him go. So all of these, you know, you have to file their complaint. To evict someone, you have to file a complaint in district court. The district court had a little screen that would tell you what the basis of the eviction was. So I just coded it. This is for non-payment of rent is number 1. 2 is termination of tenancy, and just the plaintiff's the only one that got that, and this is health and safety. And if you look at the reasons, I just went back 5 years. I could go back even further. But look at what they turn out to be. These are all non-payment of rent, right there. Non-payment of rent, that's him. That is what? Safety issue. Other ones are non-payment. We would agree you can terminate somebody for safety issues, right? And the only one that got just terminated because they don't want him to be a tenant anymore is Thompson. He's the only one that got that. If I rely on them, and they did admit it during the deposition, but I had those records there to back it up. They never did that to anybody, just him. Oh wait, there is one. Oh wait, I'm so sorry. That's too old, isn't it? Right? So I cut it off at 09. But what I also saw, if you look at it, is there were people that had 3 cases filed against them, and they weren't given a termination of tenancy. They stayed on. And they said, as long as you come up with your rent, you can stay. It's money that keeps you in your unit. And that's how it is. Do landlords dislike this? Not necessarily. Sometimes they do, but by and large, if someone is habitually late, instead of them paying what? $700 a month, they're paying what? $750 a month. Sounds like a better deal. I wish everybody was late, because then we could make thousands and thousands more. So that's really crucial to get that comparative kind of information. Any questions? I have, jury instructions and so forth. Chui is correct, starting with the law. He is correct. Unless you know the law, how much of the law is your case? 50%? 50% law, 50% facts? I remember clicking how little time attorneys would spend on their jury instructions. Jurors care a whole lot about the jury instructions. They accept it. That's the text that they decide everything on, and they quibble over the language on the jury instructions. It matters a whole lot to them about the jury instructions. If you don't have that, what do you have? You've got to know what that law is. And the only way to do it, instead of going up to 6th Circuit published and unpublished, I consider it scorched earth. Scorched earth meaning what? Reading what? All decisions, period. If that means reading all HUD familial status decisions or whatever, that's what you have to do. Well, I understand it's like 200 decisions or 300. Fine, read them. By the time you do it, you take good notes on all the issues and all the arguments that could be raised. You're very, very sharp in what needs to be argued. You really are. I mean, there's no other way to put it. I found, I'm doing a lending presentation. I was going through the law and then looking at presidential executive orders. And they said, oh, you can't bring a claim under presidential executive order unless it's been ratified by Congress in a congressional law. Well, why does that matter? Because people are treating the Fair Housing Act as not applying to post-acquisition, only applying to your initial sale or rental or purchase of a dwelling. It doesn't apply to terms and conditions or what occurs afterwards. If there's terms and conditions, only terms and conditions on the initial purchase or occupancy or sale or rental. They're looking at the language very, very narrowly. Well, the executive order by Kennedy, 11062 or something like that, in November 1962, it covers post-acquisition claims. Why is that important? Well, because Congress in the Fair Housing Act, it basically implemented and intended to replace the presidential executive order. So what does that mean? Well, by that reason alone, you can sue under the executive order and cover under and cover post-acquisition discrimination. Period. It's a real clear. I wouldn't have thought of it, but just doing the research, then all of a sudden these things start to jump out. So yeah, it's time-consuming, but it helps you get more knowledgeable. But you can't, unless you look at the case law, you won't come up with those arguments. It's real crucial. Cannot emphasize that enough. I mean, this is not fair housing. It's, I mean, how many, through employment law, how many employment decisions are there out there?
Tons.
Tons. Tons. Do you get that reading and realize, oh, there's still things I'll never know. And a friend of mine works at a big firm in labor law department. That must be nice, so focused. Purely on labor law, you must really know it. He goes, Steve, nobody knows all about labor law. It's impossible. It's completely impossible. Fair housing may is a little bit more narrowly focused in that, but yet if there isn't anything on fair housing in point, they go to general civil rights law and that. If I had to pick between the two, as a sales point, I would go with the Fair Housing Act. Who's liable under Title VII? Employer. Who's liable under Title VIII? Any person. Sure. Section 1981, 1982. All citizens or all persons. It's broader. It can get at times, co-tenants, co-occupants, managers, the liability is much broader. Defenses often are not as great in that. Anyways, questions? I thought maybe I went too fast going through it. Any questions? No? I could talk about the case filed today. Should I mention that, Mike? Or no?
Go right ahead.
Go right ahead quickly, because I'm walking around.
Okay.
Go right ahead quickly.
While you're doing that, Steve, I
Yeah.
would just ask, or I would add on the jury instructions, I get surprised sometimes by how little attention the attorneys are paying to them. Maybe they're farming that out to someone else in their firm, but there are times when a few crucial pieces of, and we do all the debriefs with the jurors too, so I get to hear this behind the scenes after the case, the words that they pay attention to during the reading of the jury instructions, and then when they take them back and look at them when they're making their decision. So I'd emphasize again how important they are.
Think about it as the case goes on, not just when it comes time. And the other one is, if there's a sequence that you use in trial preparation, and the first thing you do are your jury instructions, motions to eliminate, trial brief, then you start doing something, then your documents, then the witness preparation, and the opening and closing. But it starts with those jury instructions. That's the core of the case. Yeah, last case I did, the defendant was all over the board. They didn't do fair housing, and so much time was spent arguing with them on the jury instructions. It was a very difficult experience. And so, I got bogged down with that. So it's hard. You got to make it clear. You want to cover everything. Quote the statute, quote the regulations. If it's a sublease situation, you got to define that a sublease is the same as a lease for purposes of the act. But you got to narrow down every single point. Jurors, judges don't go step to step with you. They want it demonstrated. In a trial setting, everything gets challenged. We went back and forth for months. The mortgage company would never approve them. Then they came up with the supposed one last list of conditions. As a result of this, he lost the home. Verification of earnest money deposit, documentation supporting a deposit on 5/21/12. Like, why would they care? Perusing through his bank statements, and they find a deposit and they want to know about it. Like, that's an underwriting condition. Title commitment with no exceptions, 12-month sale history of the property, seller signed purchase agreement, and authorization to sign on behalf of the seller. Bank of Mellon is an REO property. Letter explaining low year-to-date income, updated retirement statement, appraisal, provide additional comps, mortgage insurance certification. This is all nonsense. It's all nonsense. The verification of the earnest money deposit, he had already done that 2 months ago. It came from his bank account, have the bank account which has a sufficient balance, $2,563. And then he put another $1,500 into it. He had enough to pay $1,000 out of that. Then his savings account had $16,449. What's the point? Documentation supporting a deposit of $1,580. Who knows? He's made other deposits. What about those? They never questioned those. What are they even bringing this up for? Right? It's not, they don't want to do the loan. Title commitment with no exceptions. The property, he got, turned down a little after July 19th. This property sold in a matter of what? 10 days? And there was no issue about title commitment. Title commitment isn't an issue. 12-month sales history of the property, the appraiser does that for a lender. It's right on the appraisal form. It's all disclosed on there. There were no sales history. There was 7/19/11, about 1 year earlier as of that date, there was a foreclosure sheriff's deed filed. But by the time they closed after the 19th or whatever, that's not even irrelevant. What has that got to do with anything? It's not a legitimate underwriting condition. It doesn't get any better. Seller signed purchase agreement. It's Bank of New York Mellon. So I got a copy of their deed that they signed on July 31st. Of course they had someone with authorization to sign for them. Big deal. How would that delay a sale? That makes no sense. Signed purchase agreement? If they didn't have the signed purchase agreement, they shouldn't even started processing of the loan application. They knew there was a signed purchase agreement or they wouldn't have done it. The appraisal, I didn't put it in here, the appraisal will have the date of the purchase agreement right on it. It's a standard item on the appraisal. The appraisal is the lender's eyes and ears on the property. Anything you want to know about the property, it's on the appraisal. The appraisal is all completely inclusive. Your letter of explanation is a great one. Low year-to-date income. His income, year-to-date, May 12, 2012, exactly the same as his previous salary, to the penny. There was no low year-to-date income. It was identical. He was on a salary. The salary was unchanged. So why did they write that down? Plus, he gets housing allowance. Give him a break, it's like $61,000 a year, but this housing allowance is tax-free, so it's supposed to be called grossed up, it's supposed to add 25% onto that, but, you know, too much detail. Updated retirement statement, I thought it was FHA. Your paperwork lasts for 120 days. For conventional, it's 90 days. Okay, big deal. He could, if they asked for it, I'm sure he would give it to them. But big deal, so let's look at the 401k. 15.6, 15.6, 15.3. It has been remained unchanged for half a year. What's the big deal about the retirement statement? How about the appraiser to provide additional comparables outside the subject complex? He went to a previous lender, they did an appraisal on July 9th, and they used 4 comparable sales, all condominium properties within that same complex. And then this lender had their appraiser go out, they used 6 comparables, all drawn within the same 5,000 town center. Nobody goes outside for comparables. If you have the comparables there, that's all you need. So why did they ask for it? Didn't want to do the loan. Right? I mean, it's you know. Mortgage insurance certification with 30% coverage. If the mortgage insurance is an issue, right, they would have to be reported. There's a code on HMDA. I was able to find his HMDA. He was the only property in this census tract on the 2012 HMDA. Because of the delay, HMDA was available. I found it. It's shown that their action type was a 4, withdrawn. If he was turned down because of mortgage insurance, that would be a code 8 on the reason for denial. So what does it tell you about mortgage insurance? It's not the reason for denying his loan. If mortgage insurance covers the part above 80% loan-to-value ratio, you have mortgage insurance. If you don't qualify or don't, there could be higher standards for mortgage insurance than your regular lending guidelines. However, right, if that's a real reason, then the lender will what? Turn you down because they can't obtain mortgage insurance. How many times are you aware of people being turned down because they couldn't qualify for mortgage insurance? Hardly ever. Is that a legitimate reason? Really, no. They're just speculating. It's really speculative that mortgage insurance is needed. Or there's some issue. There's no issue with it. Right. Now, is this a big deal how they reported this loan? Yes, it is. They made a federal report on this loan. This is what they told the federal government. They're stuck with it because it's true. Did he withdraw it? Did he withdraw his loan? Everything I said he wanted to do it. Right? No, he didn't withdraw it. Right? And they were, they were really, really frustrated with it. All we wanted is a statement from your company that McFurl's mortgage has not been approved, which is absolutely true. You haven't approved it, give us a statement. Look, he said, well, Bernie, the mortgage was approved with conditions. The lender was wholly responsible for not getting the mortgage process complete, and the buyer was always ready to go forward. And so he was. But again, because it wasn't done as an administrative complaint, I want to avoid Iqbal Trombley in that. So I do put in the testing evidence. Maybe I shouldn't. Length of interview, black tester, 15 minutes, white tester, 75 minutes. That tells you something right there. Right? Information not told. Information about qualifications. Credit scores around 700 with 80,000 in income. Really? Takes that much? For the white tester, 660. Minimum 5% down. Total lender look at credit score on all 3 credit reporting agencies. Hey, something may come up. They use credit score from one credit bureau and so forth. Then the other thing is, because I could get this information, this is what the HMDA showed. What do you think? For 2012. How does it look?
Should I get rid of this?
Doesn't look good, does it? You know, 78% originations to black, 35%, or white, 82 to 35. Denials, 8.7 to 35, and it goes all the way through within the MSA area, on a statewide basis, on a national basis. Pretty disparate. Why? I put this in here because of what? Iqbal land, Trombley. Iqbal and Trombley. Would that survive it? It should, right? And then in terms of discovery, what do I want to look at? It jumps out. What do I want in discovery? I want which loans? I want the white originations. 152 of them. How do I want it? CD, PDF format. This company used to have microfiche. I'm sure they have it on PDF. I want to look at those 152 loans, and what do I find out? There'll be all kinds of stuff in those files. There may even be appraisals. I mean, really attacking the reasons they gave against him, but anything else that looks really relevant. Right? He should have gotten that loan. And at that point, that also bridges the gap in terms of what? Discrimination. There's no direct evidence here, right? It's got to be proven, got to draw the inference. But if you start to look at all these things, it gets pretty compelling. Right? Someone gets it, he says, well, they should just give me the loan. I shouldn't have to go through. It's a very simple case. They should just give me the loan. But that's not going to win a trial. Trial, you have to go through the whole chronology, step by step by step. Have the jury get upset with them. Why do they keep doing with this? Why are they doing this? And get them to admit on the stand. And there may be questions I don't ask. Get them to admit it on the stand. Right? You admit that there was no issue as to the $1,000 earnest money, source of $1,000 earnest money deposit, was there? He had sufficient funds in his accounts for the $1,000 earnest money deposit, didn't he? Yes. Right? Do you think they've asked other people about it? You think they're going to be quizzing other people about their earnest money deposits like that? No. So, you know, that's just a way of breaking it down and putting it back together again. Any comments, questions?
Is that data in the information that you gave us? Or is that something?
No, this would be separate. I just filed it this morning. So.
Oh, okay.
That's not in your material because we didn't have it.
Oh,
We
yeah.
have a question
Yeah.
in the next one.
Yeah.
For electronic discovery, do you depend on them and giving you this stuff, or do you get an expert that goes there and, you know, listen to computers? You ever do that?
I haven't been that formal with it. I imagine there's going to come a day when I've had to. John, you done that? Had to get an expert in there to go through? I'm sure. Yeah, I mean, that's going to happen at some point. And I'm dealing with the school board, you know, there's E-rate data that one other school's not giving to us. I'm dealing with it on a professional level, but yeah, I imagine they would. I mean, my concern is when judges don't ride people hard enough on discovery like they're supposed to. I mean, if I can say one thing over the years, there's less and less honesty in terms of discovery from defendants. Almost like you have to guess what they have, where it is, before they'll give it to you. It's not supposed to work that way. Right, I got this, none of this information here we've gotten from them other than emails they sent off. But if you have to build your case just on what they give you, they may not be honest with you, but yeah, their obligations to preserve that data. Another thing too, Mike usually mentions it, file your case before you have communication with your defendant. There's a section of the Fair Housing Act which makes it a criminal penalty if any records are altered, destroyed, or any way, shape, or form once a proceeding has been instituted under the Fair Housing Act. The proceeding is a filing of administrative complaint or filing of a court action. File your case, then talk. Do not talk, then file. I've even done, if I get the idea that people are going to, you know, hide away documents and records, I'll send a warning notice out and I'll copy that section of the statute and tell them, you got an obligation under the Fair Housing Act to preserve all data and not touch it. In Stevenson's case, I filed a motion for default judgment because I had records, 2 different records showing that the records have been manipulated. The judge, let it go all the way through a jury trial before he ruled on that. At that point, there was no reason, because the jury trial was successful, there was no reason to consider that motion. But they had absolutely altered, I believe they had altered the records. So they're fully capable of doing it. There's a criminal penalty if you do it under the Fair Housing Act.
One point I wanted to make in terms of your discovery is that when you bring a case to the Department of Civil Rights, or HUD for that matter, I would imagine, feel free in discussing with the investigator what questions should be asked of the respondent. And if you're a respondent's counsel, if questions aren't being asked of your client that are relevant and would go to an affirmative defense, share those questions with that investigator as well. And, certainly use this as a discovery tool for both sides.
He'll do it. You can ask, and if you're not satisfied with the investigator, call Dave, and he'll, intervene as necessary. They want to do good investigations.
And these are highly complex cases. I mean, you can't expect that every investigator has a handle on, experimenting cases or anything like that. So, educate the investigator, whether you're a respondent's attorney or a claimant's attorney or a plaintiff's attorney.
How many
Because
investigators?
I know, John, you've been on the other side too.
How many investigators do you have targeted for fair housing?
I think we're at 6 now.
6. Yeah, so there's not like they're generalists, they're more focused now on fair housing, so you'll find them very responsive. Sometimes too, you don't realize that they can be extremely knowledgeable on some issues. They may know more than you or I know.
Yep.
They're not gonna sit there and tell you, but don't assume. And they're like most offices, they have attorneys on staff that are working as investigators. They understand it, they know the issues, they know the law. They may play poker face with you because they have to, but they will investigate.
They're not advocates at the role of the enforcement or the investigation stage. There is a neutral law enforcement investigator. So certainly, if questions aren't being asked that you see come across your desk from the investigators, propose them and why. So.
Yeah, they've been great help.